ambaye ni mchungaji tata wa kanisa la New International Life Church kwa sasa amefikishwa mahakamani. Hebu tuvuke moja kwa moja tusikilize ni kipi ambacho kinaendelea katika mahakama ya Shanzu.
Journey in the same fashion. 10. The first respondent, together with his accomplices, command a following that is ready to die in his extreme beliefs. If his liberty is not curtailed through continued detention pending charges, possibility of further radicalization is almost guaranteed. 11. Given the huge following that the first respondent enjoys within the country, there is a possibility that if the respondents are released, there is a high likelihood that they will interfere with the investigations and tamper with the witnesses. 12. It is in the interest of the respondents to remain in custody pending completion of investigations for their own safety and security. 13. Given the nature and seriousness of the charges likely to be presented, the temptation to take flight is high. The true identities and places of abode for the 2nd to 17th respondents are unknown, and their absence could jeopardize the integrity of key aspects of the investigations. I have perused the application and find that the same meets the general form prescribed by Section 36A of the Criminal Procedure Code, as well as Section 33 of the Prevention of Terrorism Act. What is to be determined is whether the grounds advanced by the prosecution are compelling so as to warrant denial of bond or bail with respect to the respondents. It is now settled that the standard of proof imposed upon the prosecution in establishing compelling reasons for denial of bond or bail is on a balance of probabilities. It is worth noting that the respondents did not file replying affidavits or seek leave to file in opposing the matters of fact contained in the affidavit in support of the application. However, this cannot be construed as an admission by the respondents of those facts. My view is that the factors mentioned under Sections 36A of the Criminal Procedure Code and 33 of the Prevention of Terrorism Act are not exhaustive. I say so because each case exhibits its own peculiar circumstances and is tied to the question of whether the person concerned should be granted bond or bail pending investigations or charge. It is not in dispute that prior to the instant application, some of the respondents have been in police custody ever since they were arrested and pursuant to court orders issued by the Malindi and Shanzu courts. The respondents argue that the application is an indication of dissatisfaction of the state with the orders granted by the Malindi court and previous orders by the Shanzu court. On the other hand, the state contends that the previous cases were closed and the application was necessitated by the evolving nature of the matter and the lines of inquiry to be pursued. I have not had the advantage of perusing the previous proceedings from the Malindi and Shanzu court, as none of the parties tendered the same to me. It is therefore not clear to me what offenses were under investigation in the previous applications. Be that as it may, the position of the state is that they are now undertaking investigations relating to serious offenses under various statutes, and given the lines of inquiry to be pursued, more time is needed. I agree that the evolving nature of the matter amounts to a change of circumstances which would justify institution of the instant application. However, such change of circumstances does not ipso facto warrant the continued detention of the respondents. Other than establishing a change of circumstances, the state must prove that the offenses now under investigation would call for the limitation of the respondent's liberty in the manner sought. In the application, the state has listed the offenses under investigation. I agree that most of them are serious in nature and would require more time and facilities to conduct investigations. The respondents did not dispute the fact that the investigations have since taken a new turn. In my view, for the court to find whether or not there are compelling reasons to deny the respondents bond or bail, the court must consider the grounds advanced by the state collectively as opposed to selectively. I have already stated that I agree with the state that the offenses under investigation are serious in nature. I must emphasize that none of the respondents has been charged with any of those offenses, and as such, it would be improper to pass any judgment at this stage. However, the affidavit in support of the application by the state has implicated the respondents in their various capacities. The courts have generally held that where the offense against an accused person or suspect is grave, there is always an incentive to abscond on the part of the accused person. The state alleges that the true identities and places of abode for the 2nd to 17th respondents are known. It is not known whether they are in any gainful employment. The IO deposed that the 2nd to 17th respondents were arrested by the police on various dates in the bushes within Shakahola forest, that they did not provide their national identity cards or any form of identification. It is worth noting that all the respondents are adults, and according to Section 6 of the Registration of Persons Act, every person who attains or has attained the age of 18 years is liable to registration under the Act. Section 9 thereof provides that upon the registration of a person under the Act, the registration officer shall issue an identity card in the prescribed form to that person. According to Section 14 of the Act, any person who fails to apply to be registered in accordance with the provisions of the Act commits an offense punishable by law. It is through registration that the identities of Kenyan citizens are known. The respondents did not dispute the allegation that they had failed to prove or establish their identities to the investigating officer. They did not confirm nor deny that the names on the application belonged to them. The respondents did not deny that they had no fixed places of abode. They did not state either by way of affidavit or through counsel where they stayed. I am aware that under Article 49 of the Constitution, the respondents have a right to remain silent upon being arrested. However, the purpose of this right is to guard against giving incriminating information to the police. In my view, the right does not extend to refusing to give the name and address of the arrested person. For this view, I seek refuge in Section 32 of the Criminal Procedure Code, which provides that, I quote, when a person who in the presence of a police officer has committed or has been accused of committing a non-cognizable offense, refuses on the demand of the officer to give his name and residence, or gives a name or residence which the officer has reason to believe to be false, he may be arrested by the officer in order that his name or residence may be ascertained. When the true name and residence of the person have been ascertained, he shall be released on his executing a bond with or without sureties to appear before a magistrate if so required, provided that if the person is not resident in Kenya, the bond shall be secured by a surety or sureties resident in Kenya. Should the true name and residence of the person not be ascertained within 24 hours from the time of arrest, or should he fail to execute the bond, or, if so required, to furnish sufficient sureties, he shall forthwith be taken before the nearest magistrate having jurisdiction. End of quote. It would appear that the 2nd to 17th respondents merely gave names to the investigators, but did not exhibit any identification documents. It would also appear that they did not state their addresses or places of residence. That being the case, the police have a duty under Section 32 aforesaid to establish their true identities and places of abode before releasing them on bond. I agree with the state that given the circumstances, releasing the 2nd to 17th respondents at this stage without knowing their true identities and places of abode may be tricky and hazardous to the investigations. I have already stated that the nature of the investigations will require more time and facilities. The affidavit in support of the application indicates that some of the deceased may be family members of some of the respondents, that persons believed to be family members of some of the respondents are also missing. These facts were not denied by the respondents in their submissions. It was also deposed by the IO that over 100 bodies have since been exhumed, and the number is expected to rise since the exercise is yet to be completed and the area to be covered is vast. Mr. Kariuki, learned counsel for the respondents, admitted that there were reports of bodies having been exhumed, that it is a fact that cannot be ignored. The state and counsel for the victims submitted that the court can take judicial notice of what is reported in the media. The media wields tremendous influence in our society. Newspapers, radio, television, and new media not only spread information, but also help to determine what topics and stories people talk about. High-profile cases, such as the one at hand, often attract extensive and emotionally charged coverage. Judicial officers, like myself, do not live in a cocoon. They watch television, listen to the radio, and read newspapers. It is not a secret that the incidents at Shakahola have been nationally and internationally reported in the media. In Kenya, this has been happening on a daily basis since mid-April 2023, following the arrest of the first respondent and others. The media is regarded as one of the pillars of democracy. It has wide-ranging roles in the society. Media plays a vital role in molding the opinion of the society, and it is capable of changing the whole viewpoint through which people perceive various events. The media pushes people to prejudge the verdicts of criminal proceedings. Some people use the media to influence court case outcomes. In trials, the media serves as a conveyor for popular sentiment. The media are also used to practice parallel elements of justice outside the confines of the courtroom. Kenya is a country where all the people have an upsurge of curiosity to know about the sensational and high-profile cases. People themselves start collecting information to lead the case in their mind, and in the process, the media, by publishing their own versions of facts in the source of newspapers, news websites, and news channels, pour water on the people's thirst for these sensational cases. Can this court take judicial notice of the media reports concerning this matter? Section 60 of the Evidence Act provides in part that the court shall take judicial notice of all matters of general or local notoriety. Judicial notice is defined in Black's Law Dictionary as follows. I quote, "A court's acceptance for purposes of convenience and without requiring a party's proof of a well-known and indisputable fact. The court's power to accept such a fact, the trial court took judicial notice of the fact, water freezes at 32 degrees. That's an example. It is further defined by Oxford Dictionary of Law as follows: the means by which the court may take as proven certain facts without hearing evidence. Notorious facts may be judicially noticed without inquiry. In the case of Ngunjiri Wambugu versus Inspector General of Police and two others, Makovu J took judicial notice of media reports which were in the public domain and widely reported in the local dailies and news on all broadcasts, as sufficient proof that there were violations of the petitioner's rights. Similarly, in the case of Republic versus Diana Suleiman Said and another, Mhubiri J took judicial notice of media reports concerning attacks in Lamu over a period, among others, and reviewed the order of release of the accused persons on bond. In Daniel Ogwoka Manduku versus DPP, Ogola J observed as follows, I quote, "On the issue of media reporting, this court has taken judicial notice that the petitioner has been the subject of adverse media reports, both print and audiovisual. The cumulative effect of such report is to paint the petitioner in bad light. While media reporting is not likely to influence the court, the petitioner is likely to be judged adversely in the court of public opinion." End of quote. In Republic versus Kunguru Martin Opio Jr., Wakiaga J took notice of adverse media publicity to find that the security of the accused person therein was at stake. Having considered the above authorities, my view is that the court can take judicial notice of media reports depending on the circumstance of the case and subject to the conditions stipulated by law. Media reports cannot be relied upon to prove, for instance, the guilt or otherwise of the suspect, however much he may have been implicated or vindicated in such reports. They cannot be relied upon to resolve issues in controversy. The media houses in and outside the country have been reporting incidents as they unfold at Shakahola. A simple Google search of the name Shakahola leads to a great number of links containing horrendous news and information on the incidents under investigation herein. The respondents, through their counsel, admitted that several bodies have since been exhumed at the scene of the alleged crime. that the whole world is talking about Shakahola. Counsel for the respondent further submitted, rightly so, that we cannot ignore what is going on and we should all be concerned. For close to a month now, the Kenyan media has been reporting on the happenings at Shakahola. There has been news on bodies being exhumed and survivors being rescued. As rightly submitted by Mr. Abubakar, the chief government pathologist has been giving media briefings on the post-mortem exercise at Malindi. Reports indicate that when exhumations resumed on 9th May 2023.
Na mtazamaji